We are here in 2022 CR 133, the state of Kansas versus Gregory Bryant. Jill Gillette, Greenwood County Attorney, appears for the state. Mr. Kelly appears in person and pro se. Mr. Kelly, I'd ask again, are you sure you don't want an attorney to help you in this case?
Not this time, Judge.
All right.
And can I correct the record? It's
Do that.
okay. All right, that's fine.
It doesn't hurt to check because I do make mistakes on that, but they go by the year the case was filed, and this was filed in 22.
All right, thank you.
You're welcome. Now then, we are set for motion hearings. Defendant being charged with possession of marijuana, a misdemeanor. Operating a motor vehicle without liability insurance, a misdemeanor. Ms. Gillette, did you ever get any indication that there was insurance? Any proof, Mr. Kelly?
Buckle up, this is Kansas. Meet Gregory Kelly, no lawyer, no filter, just raw defiance. He's standing alone, taking on the judge and prosecutor head to head, battling over bond, probable cause, and shocking claims of planted evidence. Paraphernalia
and registration, are there any of those you want to admit or take a no contest stand to, Mr. Kelly?
Not at this time, Judge.
Okay.
I only wish to address the due process violations.
Okay. And let me pull those up here. You feel like this request for discovery, you've got what you need there?
No, Judge, I have not.
What else are you needing? Did you get copies of the reports?
I still haven't received the full drug analysis report. I'm still missing page 2 of that analysis.
Ms. Gillette, do you know anything about page 2 of the KBI lab report?
Judge, we scanned and emailed it to him on November 30th.
It was incomplete.
Is it possible the second page being on the back sheet may not have come through? What is the second page that's missing?
The analytic.
There's only 2 pages. There's this page and there's this page.
You have both of those, sir?
I do, but there's no analytic report on there. It doesn't give a breakdown of any of the substance that was tested. She only said that she tested a substance, but there was no report. There was no basis to her report as to how she came to that conclusion.
Well, I think there is. If you want to point that out to him, Ms. Gillette, or I mean, you're not his lawyer, and he shouldn't need you to practice law and explain that to him. But if you want to just give a very brief.
This is the portion of the lab report that says what the substance is. This is what it verifies, that lab item number 1 is the same as contributor number 1. So this is the number that's assigned by the sheriff's office to the item when it gets certified mailed in. This is the number that the lab gives it when it comes in. So that identifies it as to your case. This information up here identifies it as to your case. This is the officer who submitted it. This says what it was and is a brief description. And then this is when they start the exam, complete the exam, and this says what they found in it and what the net weight total of the drug substance is. So she confirmed that it was THC marijuana and that the weight was 0.54 gram out of marijuana cigarettes. And then down here just says what type of tests she ran to confirm. And down here is her certifications of the methodologies. And then down here is her certification of her training and proficiency is correct. At this time, it was over 4,000 samples, but having dealt with these lab technicians, she's probably done over 5,000 by now, or maybe even 6,000 samples. So when they get on the stand, then I qualify them as an expert in the courtroom, and then the lab report can be admitted after they certify their results and their credentials.
Okay, so that should take care of that, Mr. Okay. All right, what else did you feel like you didn't get in your discovery, sir, if anything?
I'm curious. She said something about an admission during arraignment. What was that admission affected to? What
admission did you make during
arraignment? Admitted here this morning, and you admitted at your first appear, not at arraignment, at your first appearance. that the tag on the vehicle was not current. And so the transcripts have to be paid for to the court reporter. And if you want a copy of the transcript I've already ordered, you contact the court reporter, Jerry and Noel, and then you can get a copy of that transcript that you admitted that the tag was not legal on the vehicle, and that is what you were initially pulled over for. So an admission on the record is an admission against own interest, and it's
That's
admissible.
why I need to clear up. Appreciate that.
Okay, and I think technically you're both right that the first appearance on a misdemeanor is an arraignment, so that matter's covered. What else? Anything else, Mr.
Yeah,
Kelly?
there is a couple more things. It was mentioned that there wasn't an affidavit in support of probable cause, and I have not received that. You said it was sealed, affidavit in support of complaint.
Well, it suffices for both the complaint and arrest.
Yeah, but it wasn't signed by a judge, so therefore no probable cause determination was ever made.
There doesn't have to be probable cause determination on a misdemeanor. That's for a felony. On the probable cause of the officer at the time is sworn to by the officer presented to the judge at the time that we file the complaint.
Yeah,
And it is sworn to under oath, subscribed and sworn to before Gary Murphy, notary. So it is a signed, sworn to affidavit.
well, I'm going to object to that because
Okay.
there has to be a certificate of probable cause, whether it's a felony or not. There has to be a determination of probable cause.
And you will find complaint information, arrest. Okay, do you see a warrant on that, Ms. Gillette? Inactive warrant? That's
No, inactive warrants aren't necessary under the law.
not necessary. Okay, we had that conversation, I think, last time too, that typically in Butler County, I do sign those after the fact, even though they've already been arrested. In this county, I don't believe they typically are filed, but the court does make that determination upon the affidavits.
Okay, well, for the record, I'd like to object because I believe that the law says that I should have a probable cause determination, and one has not been made at this point to my knowledge.
Okay, but I'm telling you, sir, that I did read the probable cause affidavit, and I have determined that there is enough to proceed at this.
I just want to be on
I
the
need Ms.
record.
Gillette to file a document accordingly for me to sign. I can do that, but you were arrested on probable cause. You can be arrested on the officer's probable cause, or you can be arrested on a warrant. And you were not arrested on the warrant, you were arrested on the probable cause. Some jurisdictions, as I say, will do what's called an inactive warrant, but that I do not believe is required. But in any event, I'm telling you that based on the affidavit provided by the officer, August 17th, 2022, I do believe that there is cause to proceed with this case, or you wouldn't be sitting here.
Right from the start, the judge asks, "Are you sure you don't want a lawyer?" Kelly says no, and with that one choice, his fate is sealed. Every motion, every argument, every word from here on, he stands completely alone.
By his making that decision, which was not his to make, he put me at undue hardships, and I could have gotten no OR bond had I went before a judge.
All right, so as I understand your position, anytime an officer in the middle, was this in the middle of the night? It was, wasn't it?
No, it was approximately 6 or 7 p.m. in the evening.
Yep. Okay, after the courthouse was closed. But it's your position that anytime, 24 hours a day, an officer stops someone, they must take them, if the individual asks, immediately to a judge for immediate arraignment?
That's not my decision. That is the Supreme Court's decision, who has said that the courts are open 24/7, 365 days.
And you're entitled to immediate arraignment. And what is your authority again, please?
Well, KSA 8-2104, subsection A, subsection 1. Also, KSA 22-2901. He has an obligation when I demand it to be
Okay.
taken before a judge.
Quote those, please. Quote the provisions you rely on.
What does that mean?
That means read the statute that you're relying on.
Yes, it says one person to be taken.
Okay, which statute are you reading from now?
I'm reading from KSA 8-2104.
Okay.
It says when a person is stopped by a law enforcement officer for any violation of any provision of the Uniform Act regulating traffic on highways not amounting to a felony, the person shall be taken into custody and taken without unnecessary delay before a judge of the district court as specified in subsection D of KSA 8-2106 and amendments therefore. If subsection 1 says such person demands an immediate appearance before a judge.
Okay.
And then also to look up KSA.
Is it 2901 or 20? I thought you said 2109.
I've got 2901, Judge.
29. Maybe I wrote it down wrong. 2901. Okay.
Subsection 1 or section 1 says except as provided in subsection 7, when an arrest is made in the county where the crime charged is alleged to have been committed, the person arrested shall be taken without unnecessary delay before a magistrate of the court from which the warrant was issued. If the arrest has been made on probable cause without a warrant, he shall be taken without unnecessary delay before the nearest available magistrate, and a complaint shall be filed.
Anything else you want to say on that?
That pretty much sums that issue up.
All right. And Ms. Gillette, the state have a response to that?
We do, Your Honor. So a suspect may be stopped if an officer reasonably believes they have committed, are committing, or are about to commit a crime, and may demand their name and address, and may take the person into custody if they believe that the crime is being committed, especially if it's a misdemeanor or a felony. And in some circumstances, when individuals are in an exigent circumstance, such as driving a vehicle, they are able to take them into custody and seize the vehicle to stop them from continuing about the way. They may also impound vehicles if they're on a highway, parked unsafely, not tagged, not have proof of insurance in them, because the proof of insurance and registration must be in the vehicle. In this case, the defendant was stopped under the circumstances of having an illegal tag. Upon investigation, he had no insurance available in the vehicle, and that was not given to the state within 10 days. So technically, we didn't have to dismiss that charge, but we did because he did provide that he had insurance at the time, and we were able to verify. When it comes to bond schedules and the automatic bond schedule program, Kansas court rules set out the court-operated bond program and how the rules of the judicial districts should apply. And in 2022's version, the administration rule became effective at February 1st of 1998 and established the procedures and qualifications for release of accused persons from custody in situations other than upon a specific order from a judge of the district court. The automatic bond schedule is set by the chief judge and the judges of the district in accordance with the statute and law set out in the Kansas Court Rules 23. There were certain individuals that wrote letters to the Attorney General back at the time. An Attorney General opinion, AGO 1994-25. So it's the 25th Attorney General opinion of the year 1994 about automatic bond schedules at that time, as set out by the statutes. They require sureties. They require individuals to ensure that the person had to have all these different things, such as their phone number, their address, where they can be contacted, where the surety can be contacted, that a 10% bail bond if cash or surety is allowed. And that Attorney General's opinion upheld the fact that an automated bond schedule can apply because
Kelly launches into his defense: missing lab reports, no judge at arrest, due process violations. It's straight out of the sovereign citizen playbook: legal jargon, fake authority, endless jurisdiction rants. But the prosecutor stays cool, dissecting his claims like a teacher schooling a student in real time.
Prior set for the courts so that each person would have a bond set by the judge of the district. In this case, Judge Rickey is our current chief judge, but he oversees the other judges in these kind of administrative rules. Each judicial district is allowed to set their own automatic bond schedule in accordance to the rules of the Kansas courts. They have been upheld. Kansas Court Rules 3.309, pretrial release of the Kansas Rules of Judicial Districts in the 2022 also sets out what offenses are specifically designated for those schedules. Certain offenses have to have C judge, so the person has to be arrested and then the judge makes a determination. It doesn't mean that the person themselves have to before the judge. But due process clauses say that the county attorney, which would be me, files a complaint and or views the ticket that comes from the officer if it's a misdemeanor and someone is arrested. And then I make the determination if the charges should stay as the ticket provides or if they need to be amended up or down. And I do that review within a certain amount of time if someone remains in custody and does not bond out on an automated bond schedule. Then at that time, they have a first appearance where bond may be set and or I submit a warrant to the court with the probable cause affidavit of the officer and a judge reviews it and sets the bond. I know that this is a lot of technical stuff that I am quoting, but that's why a trained attorney often helps someone. And in this case, I believe I'm having to try to teach the defendant the law. The automated bond schedules fall under Supreme Court Rule, Kansas Court Rules 3.309, pretrial release, 23 operated bond programs, Kansas rules of the judicial districts. And so there are different rules that allow the judicial districts to set their bond schedules. And it falls under the judicial districts in the actual Kansas court rules. They are ratified and supported by the Kansas Supreme Court, and they continue to be supported by the Kansas Supreme Court. If you turn to Haney versus the state, in that case, the defendant had Board of Indigent Defense Services, and among others, for his arrest and for his defense in his case, believing that he was unlawfully arrested and believing that his attorney did not do the things that were necessary. There is a certain amount of immunity granted under the law when an officer acts under his belief that the person is committing a crime. Then he is allowed to take the person into custody. And the Haney case talks quite a bit about that and goes into details about and everyone involved in the case. So that case sets out quite a bit about immunity for the courts and the Indigent Defense Services because we have to operate on those bases.
All that stuff about the bond and the set bond and that can all be overridden by the judge at any instant by her saying, I grant you an OR bond. So they're nothing but guidelines. And it has nothing to do with the fact that my due process was violated by not be taken before a judge and allow her or that person, a judge, to decide my fate in that matter. The deputy took that upon himself personally. The Supreme Court case has no bearing on my case because there is no parallel relation to that case in my case. And so bond has nothing to do with the fact that I was denied access to a judge. I think that KSA 8-2104 is pretty blatant in the fact that it says that I had that right. And that right was denied to.
A judge due process isn't violated. The Supreme Court's already determined it's not a violation and that that you don't have to be taken in person to the judge for the judge to
You do
rule
that.
on
Okay,
Yeah.
hang on. I'm
No.
giving her the final word on.
the judge.
I object to her opinion.
Hang on, go ahead, let her finish her thought.
Okay.
The law doesn't mean that you have to be taken personally before the judge. It means that the judge may assign a bond to you in a manner that is fit and determined by the courts and by the Supreme Court and by the law. And in this case, the law has determined that the automatic bond schedule functions as a judge pre-setting a bond. If you don't like the bond, you can contest it at your first appearance. But in this case, the bond was set by the automatic bond schedule, allowing the defendant a swift release, and he was released within the same day according to the bond schedule that is preset by a judge. In this case, Judge Rickey is our chief judge and has been for quite some time, and he would set our automated bond schedule for 20.
He could set that for OR, he could set that for surety, he set it for surety. Your last word on this, Mr. Kelly.
Well, I would like to object because, she keeps saying that's the law, but she hadn't stated any laws relevant to that matter. She's sidestepping the fact that I wasn't taken to a judge and she wants to turn it into a bond issue, but it's not a bond issue. That's only secondary. The issue is the fact that I was denied due process of law by not be taken to a judge after I demanded it. KSA 8-2104 says specifically that if I demand it, it has
Quote that again, quote that. Quote what it says. Don't just paraphrase it, but quote it. Say it, read it exactly the way it says.
except as provided in subsection 7, when arrest is made in a county where the crime charge is alleged to have been committed, the person arrested shall be taken, not any paperwork is what she stated. It says the person arrested shall be taken without unnecessary delay magistrate of the court from which the warrant was issued. If the arrest has been made on probable cause without a warrant, he shall be taken without unnecessary delay before the nearest available magistrate, and a complaint shall be filed there forthwith.
Okay, I'm going to stop you there.
Yes.
Now it's my turn to talk. That statute served multiple times.
Yes.
Never once did you notice or stop or specify a very key provision, and that is, quote, without unnecessary delay, quote. Now, you interpret that as immediate. Go and get the magistrate out of bed or out of a church service or whatever he or she is doing, that it has to be immediate. But unnecessary delay could be the next available court date, the next available date the court is open. And that is what you were provided. You were given a bond that a chief judge had set, and he can set those scheduled bonds, OR or surety, and he set it as surety. So you were given immediate bond, which you took advantage of. You were also brought before the magistrate without a...
This is where the fireworks begin. Kelly insists, without delay, means he should have seen a judge instantly, even at 7 p.m. But the judge calmly schools him. Kansas runs on an automatic bond schedule approved by the chief judge, legally the same as a judicial decision. With steady patience and razor-sharp logic, the judge starts dismantling Kelly's fantasy piece by piece.
Of a weapon. But yet, he planted that weapon inside my vehicle after it was already out. I was already in custody, so there was no fear of having anything destroyed, any evidence destroyed. A harm to myself. I was in handcuffs, so therefore I was not a harm to him, and he had no exigent. He created his own exigent reasons. So in other words, he broke the law in order to enforce.
So we are, again, for evidentiary purposes, relying on the officer's affidavit? Is that the document you're referring to?
Yes, he stated himself.
Okay. All right. He says on Wednesday, August 10th, 2022, I, Deputy Blake Fisher, working for the Greenwood County Sheriff's Office, was patrolling westbound on US Highway 400 at the approximate 327 mile marker in Greenwood County, Kansas, when I noticed a white Ford F-150 pickup truck also traveling westbound on US 400 at approximately 327 mile marker in Greenwood County, Kansas, bearing an expired Kansas temporary tag of, and then he cites that. So stopping there for a moment. Okay. Oh, and he goes on to say, with the displayed expiration date of 7/22/22. So you're not disputing those facts. You're stipulating that that is correct. He did stop you August 10th because your temporary tag expired 7/22. We're agreeing to that. That's not the issue, right?
No, that's not the issue.
All right. And then he says he noticed the tag was flapping. He ran the temporary tag through his dispatch, and I'm skipping ahead since we have a stipulation to the affidavit, the part you're concerned about. I turned on my overhead emergency vehicle lights. Once the vehicle was fully stopped, I approached the driver's side window where I was greeted by the driver, Gregory Kelly, informing Kelly with the reasons of my traffic stop. While I was speaking with Kelly, I smelled the odor of marijuana coming from within the vehicle based off my training and experience. I asked Kelly to provide me with his driver's license, current proof of insurance as well, the registration on the vehicle he was driving. Kelly was able to provide me with his driver's license, however, was not able to provide me proof of the current proof of insurance nor the registration of the vehicle. So you're agreeing to all of that part of it, sir. Is that correct?
That is correct so far, yes.
Then he was standing at your driver's window, ran your license through dispatch, make sure you didn't have any outstanding warrants. Dispatch later informed me Kelly did have a valid license, didn't have any outstanding warrants. After checking the status of, I'm quoting now, after checking the status of Kelly's driver's license, I requested Kelly exit his vehicle, which he did comply with. As Kelly was exiting his vehicle, Kelly informed me he had a knife on his person. I retrieved a pocket knife off of Kelly's front right-hand side pants pocket. I secured the pocket knife within the vehicle Kelly was driving. I then instructed Kelly to place his hands on the front push bumper of my patrol vehicle, which he did comply with. Okay, so how does that fit in with what you were arguing, sir?
If you go to the end of that report,
okay,
it explains that due to officer safety and the fact that there was a weapon in the vehicle.
Okay, well, the next paragraph says, I then performed a pat-down search of Kelly's person for officer safety purposes. As I understand it, he'd already taken the knife off of you and put it back in the car. I then performed a pat-down search of Kelly's person for officer safety purposes. After the pat-down search of Kelly's person was concluded, I secured Kelly in handcuffs before performing a probable cause search of the vehicle. For officer safety purposes, due to there being a knife within the vehicle, and that's what you're in reference to?
Yes, it is, Judge.
And I being the only deputy on the traffic stop. Once Kelly was secured with handcuffs, I provided Kelly with his Miranda rights. I asked Kelly if he understood the Miranda rights. I provided him with, Kelly stated he heard what I was saying, however, was not saying he understood anything. I then informed Kelly I smelled the odor of marijuana coming from within the vehicle he was driving. I informed Kelly I had probable cause to search the vehicle based off of the odor of marijuana. Kelly stated he did not give me consent to search the vehicle. I informed Kelly once again I had probable cause to search the vehicle based off the odor of marijuana. Okay, now is there anything else in the report about the knife or anything else you're wanting to argue at this point, or do you want me to continue?
There are no other mentions of the knife after he used that as his.
All right, now, what is it about the knife? Make your argument again about the knife, about what's your argument about the knife? Just make that again, please.
He planted evidence in my vehicle in order to have exigent reasons.
Exigent reasons for your arrest or for the search of the car?
For a warrantless search.
All right, so you think your argument is he was only searching the car because he found a knife in it?
No, he
That
was
he had
only.
put in the car?
No, there was no exigent reason listed other than the knife, a knife that he placed in my vehicle. What exigent reasons did he give? He didn't give anything other than the fact that there was a knife in the vehicle, and that was his reason to search.
Okay, I understand your argument. Your response, Ms. Gillette?
Your Honor, the knife has nothing to do with probable cause and exigent circumstances in this case. I think the defendant is confused because, again, this is a law topic. Exigent circumstances is to prevent the destruction of evidence and or things that are going on. The Supreme Court has determined that the odor of raw and or burnt marijuana coming from a vehicle provides probable cause to be able to search that vehicle. As stated in the deputy's affidavit, he smelt the odor of marijuana, and therefore that gave him probable cause to perform a probable cause search of the vehicle. Exigent circumstances say that when it's in a vehicle that is able to move, as in State v. Goff, GOFF 239 Pacific 3rd 467, and that was decided in 2010. There is a long history in the state of Kansas going back to the 70s that allow officers to search vehicles based on probable cause of smelling marijuana. He must have the odor, a reason to have initially stopped the vehicle, and a belief that there is that drug in the vehicle. Once the search begins, it's based on the probable cause of the odor. The exigent circumstances that a vehicle is mobile, the vehicle can be easily taken somewhere else and the evidence disposed of, and that the evidence would be mobile at that point because it's in a vehicle. So exigent circumstance does not mean emergency or officer safety. It's a whole different ballgame. Officer safety is a different thing that allows when someone is going to be arrested or removed from a vehicle and be in close proximity to an officer, that for officer safety, they can pat down the person to make sure there's not weapons on them. In this case, there was a weapon present, which is a knife. It was not pulled or brandished, but officers often secure weapons so that they cannot be used to harm. Since Mr. Kelly was removed from the vehicle and he could already be arrested on misdemeanors that are already occurring, he is removed from the vehicle. The pat down is to make sure there's not weapons. He disclosed he had a knife. The knife was secured in the defendant's vehicle. That also prevents the officer from accidentally leaving it in his car, removing it somehow to a different place where it could be lost or messed with. If the vehicle is going to be towed, then it would be secured and included in a tow inventory. And that way it's in a safe place. Deputy Fisher could have also taken the knife back to his own patrol vehicle and secured it. Someone is being arrested and removed from a vehicle. They can't take a knife into the jail because that's trafficking contraband. They can't take any other weapon or any other things that would be paraphernalia into the jail. And so later on, there would be another pat down and or strip search of a defendant at the jail. But this is a cursory search of a pat just for officer safety to make sure there's no weapons present. And they find all kinds of weapons and all kinds of things on people. And sometimes they feel like something else. And sometimes they brush through and find a bag full of meth and a bag full of marijuana on. But when you pat them down gently, you're looking for weapons, anything that can hurt you for officer safety. Officer safety check is apart from exigent circumstances on a vehicle. It's not part of the same thing. However, if an officer is patting someone down because a person is mobile and a person can destroy evidence, and they do find a bulge or something in someone's pocket when they're patting them for officer safety, then that becomes evidence that is found and it can be removed and held as evidence. In this case, no evidence was found on the person of Mr. Kelly. It was found in his vehicle with him, which he had sole control over. The exigent circumstances has nothing to do with the officer safety and the knife. That is purely officer safety in this case. And the pat down of Mr. Kelly, he admitted he had a knife. A quick pat down and put the knife back in the vehicle so it's secure and not within reach of Mr. Kelly against the law. It has nothing to do with the exigent circumstances. That would be the odor of marijuana and the belief that there are drugs in the vehicle based on the odor of marijuana. They are two separate, totally different things, which is why the knife is never mentioned again. The knife is not something Mr. Kelly is charged with. It would not be evidence. It is not planted. It is simply secured back in his vehicle for officer safety so he.
Now the tension spikes. Kelly claims the deputy planted a knife in his truck to fake a reason for the search. The prosecutor stays cool, breaking it down with precision: officer safety versus exigent circumstances. What follows is raw courtroom drama. Wild accusation meets cold, unshakable legal reality.
Okay, Mr. Kelly, I saw you nodding your head negatively, or not nodding, but moving your head negatively as if you weren't agreeing with what she was saying. Or you want to have the final word on this before I make a ruling?
I do, Judge.
ahead,
I think that the prosecutor is confused of the law because she's sitting here talking about probable cause. Probable cause is no excuse to search a vehicle unless you have a warrant. The exigent reason is the only reason that he had cause to search a vehicle, and he didn't list one. So if the knife was not the exigent reason, what was the exigent reason? He didn't list one other than the knife. So we're not here talking about whether he had probable cause. Marijuana might have given him probable cause, but it did not give him authority to search my vehicle without a warrant. Only exigent reasons do, and there's only 3 of them: harm to myself, harm to others, a chance that the evidence might be destroyed. There was no chance of the evidence being destroyed. I was already in custody, so therefore I could not go back to my vehicle. He had already said that he was towing my vehicle because I had no insurance. So what was his hurry? Why didn't he not just take it back to the yard, file for a warrant, and therefore he'd have probable cause to search? He listed no exigent reason other than the knife. Exigent reason, which he did not list. He had no warrantless probable cause. There was none. He'd already secured the vehicle. He'd already secured me. There was no reason for him to search that vehicle without a warrant.
All right. Thank you, Mr. Kelly. The courts have well settled the fact that the nature of the mobility of the car itself creates exigent circumstances. Leaving the car sitting alongside the road could allow someone to tamper with the evidence, whether it be you or someone else. But the courts have made it clear that the exigence exists in the nature of the car and its mobility, and that does, if the officer has probable cause, he can search the car without a warrant, that he doesn't have to get a warrant, leave the car along the road and go get a warrant. And the officer says his probable cause, let's see, second paragraph, first page. The deputy says, at approximately 1828 hours, I turned on my overhead emergency lights on my patrol vehicle, initiating a traffic stop on the vehicle. The vehicle came to a complete stop on U.S. Highway 400 at approximately F-75 road in Greenwood County, Kansas. Once the vehicle was fully stopped, I approached the driver's window where I was greeted by the driver, Gregory Kelly, informing Kelly of the reasons for my traffic stop. While I was speaking with Kelly, I smelled the odor of marijuana coming from within the vehicle based on my training and experience. So traffic stop, smell of marijuana coming from within inside the vehicle, mobility of a vehicle. And then when he did the pat-down search for officer safety and put the knife inside the car, but then he goes on to explain why he searched the car. I smelled the odor of marijuana coming from within the vehicle he was driving. I informed Kelly I had probable cause to search the vehicle based off the odor of the marijuana. So he wasn't searching the vehicle based on what is alleged in this affidavit that I understand the parties have stipulated to for this hearing. He wasn't searching because of danger to himself, but rather because he believed a crime was being committed, that crime being the possession of marijuana. And therefore, because the courts have established that he can search the car under those circumstances, he alleges he did.
And here comes the hammer. The judge lays it out. Smell of marijuana plus a moving vehicle equals probable cause and exigent circumstances. Motion to suppress? Denied. You can feel Kelly's entire argument crumble as reality crushes his theory.
Stated in the Constitution does not mean attorney. It means counsel.
Oh, okay.
There's a difference between counsel and attorney. Could be anything. Could be an advocate. Could be myself. Could be my next door neighbor. I'm afforded the right of counsel, and that does not mean attorney. That has been construed throughout history as meaning attorney, but it does not mean attorney. That is how I'm describing that.
So you are upholding your right to obtain counsel, non-legal counsel.
That's correct.
Friends, family, yourself, but you do not want an attorney.
That is correct.
You're waiving your right to attorney, but not to friendly counsel from non-legal sources. Okay. Did I get that right?
I'm not waiving my rights to an attorney. I'm not waiving my rights to an attorney. You're trying to box me into something there.
No, I'm not trying to box you in, but we are kind of hung up on semantics, I think. All right. So you're not waiving your right to an attorney, but you don't want an attorney, and you're not going to use an attorney. Is that correct?
That is correct, Judge.
And you're going to proceed on your own behalf without having someone appear for you. You're going to make your own arguments. But if you want to go talk to your friend and have your friend give you non-legal counsel, you'll do that.
But yes.
Okay.
Difference.
I think I understand that. And I think we've made a record of that. But the bottom line is you are voluntarily proceeding without a lawyer today and for future hearings, unless you change your mind.
That is correct, Judge.
All right. Well, I'm still going to have the record reflect that you are knowingly and voluntarily proceeding without an attorney, knowing that you have the right to hire an attorney, and knowing that if you cannot afford an attorney, you can apply for a court-appointed attorney, and if you qualify, one can be appointed.
Yes, Judge, I understood that.
Another telling moment. Kelly won't say he's waiving his right to an attorney. Instead, he claims counsel could mean friends or neighbors. That's not law, that's pure ideology. A window into the anti-system mindset where belief replaces reality.
You guys can negotiate that. In the meantime, you're still wanting a jury trial if you can't work it out. Are we set for jury trial in June, Missy? Do we have him on a docket?
We do have him set for a jury trial.
Okay.
I believe it is June.
So do you have those dates, sir?
Yes, I do.
Okay. Now, the one when you come in for pretrial,
Yes.
that will be by Zoom on Monday, June 12th.
Okay.
And if you and Miss Gillette before then work out a plea agreement, you can announce it and enter it at that time.
Okay.
If you can't, then we'll plan on the jury trial, but understand it's like before. There are going to be a number of you set at the same time for jury trial. One will go, the others will have to, but if the two of you can work something out, great, we can have you enter it at that time.
Thank you, Judge. Appreciate it.
You're welcome. Okay, I don't hear anything else that we need to settle today. Ms. Gillette, does the state have anything we need to resolve?
No, Judge, I don't think so.
All right, thank you. Mr. Kelly, anything else we need to address or resolve?
After all that, the judge sets a jury trial for June. Kelly leaves the courtroom still self-represented, still trapped in his own illusion of constitutional power. This case is a brutal lesson. Challenge the system without understanding it, and the system will teach you the hard way.